And as expected, after the landmark EWS verdict from the Supreme Court of India, a review petition has been filed against that order, against that judgment of the Supreme Court. Now, the review plea has been filed by the MP and the Congress leader, Jaya Thakur. The review plea challenges the judgment of the top court. By 3:2, the Supreme Court had upheld the economically weaker section criteria created by virtue of change in Part 3 of the Indian Constitution, and by an amendment. That change was upheld. It was said that it's a plausible ground under which the court can make a decision like that and the government can make a discretion like that. Cutting across to my colleague Ananya Bhatnagar, who's with us on the broadcast. Ananya, if I'm not correct, this is not the first review petition.
Well, definitely, this is the first review petition into this matter. Remember that this matter has to be taken up by a larger bench because there was a 3:2 ratio judgment that had come in into this particular matter. And what is very, very clear at this point of time is that Congress leader from Madhya Pradesh has knocked the Supreme Court, challenging that particular order, saying that there are some findings into that particular order that are violative of the Constitution of India. In fact, the basic structure of the Constitution of India.
Ananya Bhatnagar getting us all the details on that very important story. So I'll want to cut across back to Ananya. Ananya, one of the key grounds on which the EWS quota was challenged was that it violates the basic structure of the Indian Constitution. The court by 3:2 held it does not. And that's precisely what is being challenged in this review yet again.
Well, definitely, Anusha, this is the exact point where, in fact, it has been challenged. The basic structure is being violated. It's again the claim by the petitioners and the reviewers, basically seeking a review of that 3:2 judgment. They also say that, in fact, the 50% ceiling limit is a very important ceiling limit and is based on the basic structure of the Constitution. And the particular judgment allowing for the EWS reservation is actually hindering that 50% ceiling limit. Apart from that, what has also been said is that the fundamental rights of those.
Ananya Bhatnagar getting us all those details. The connection is patchy. We'll just try and fix that. But EWS quota, of course, continues to be a very important debate in this country. There were various parties, including the DMK in the south, which had said that this judgment is a setback to the kind of social justice that was envisioned by granting certain kind of reservations to the SC and ST community. Now, once again, with the review petition being filed, we have to wait and watch whether the court will take it up. Most of the review petitions in the Supreme Court, more than 95% of the review petitions on the Supreme Court are dismissed unless there are huge grounds or some new fact or law that has emerged that was earlier not taken into account. Well, one of the dramatic changes that we have seen in a curative petition was when the judgment on homosexuality came in this country, when it was held that 377, or the manner in which the entire matter was earlier decided by Supreme Court was not correct. That was one of the, outliers, an exception that had happened. But most review petitions don't end up well in the Supreme Court. Ananya, coming back to you, it was expected that there were various parties like DMK which had made a statement that they're also going to file a review petition in the court. Other than this, are we expecting other pleas to come up?
Well, we can definitely expect more and more petitions to come in review of this particular 3:2 judgment. And I'll read down some of the portions of this judgment actually for you. In fact, I'll read the first paragraph. The constitutional validity of the 103rd Amendment of the Constitution was challenged before this honorable court, and 5 judges have decided the issue as to by way of four separate judgments with different reasoning. The judgments upheld the 103rd constitutional amendment, and by passing 3 different judgments with different reasoning. One judgment passed by Justice Ravindra Bhatt along with Chief Justice of India, and it is detailed down as to which judgments are given out. Then by the aforesaid amendment, Article 15 and 16 of the Constitution were amended by inserting Clause 6, Clause 5, Article 15, inserting, and that's how the petition goes on. But what is very, very clear at this point of time, Anusha, is that this is the first review petition, first of all, that has been filed against the EWS judgment. Secondly, what is very, very important is that this would now be heard by a larger bench. But as you were also pointing it out, that review petitions don't really go well with the Supreme Court. They're not very effective until and unless there is a very, very strong ground, especially when there is a 5 judges bench which is giving out a 3:2 ratio verdict. So all the points have been considered by these petitioners, and then they have moved a review petition basically challenging the particular judgment that's been passed in the 3:2 ratio, relying mostly upon what Justice Bhatt and Justice Uday Umesh did, that is the then CJI judge said.
Yeah. And absolutely, Ananya, the points that were the dissent of the two honorable judges, including the former Chief Justice of India, UU Lalit, those grounds are will be invoked in the review petitions. And as Ananya is pointing out, it was expected that DMK and others will file a review petition, but officially, this is the first review petition that has come on record.